Our goal is to have business owners and executives be provided with information for planning for success, hence planning successfully, in an integrated relationship between law and business. Having quality, trusted advisors on your team early on as possible provides you with the best chance of success and your best chance of enhancing the success if you're already experiencing some. I believe it was Benjamin Franklin that said the oftentimes quoted phrase, quote, "If you fail to plan, you are planning to fail," end quote. Through this show, we plan on discussing different aspects of the law and how each of them relate to business, how quality advisors like folks from my firm can help you start, grow, and enhance, and even sell and transition your business. We want your business to be planning successfully as opposed to planning to fail by failing to plan. With that brief overview, I wanted to quickly introduce myself and then ask my two guests to do the same. As I said earlier, I'm Matt Thiry. I'm a shareholder at the law firm of Davis, Matthews & Quigley, and my practice focuses on the areas of business law, business litigation, and fiduciary litigation. I'm a self-admitted contract junkie. I enjoy negotiating and drafting a wide variety of contracts. In addition, I have significant experience litigating business disputes such as contract cases and business torts. In addition to working for clients, I'm also an arbitrator and a mediator registered with the Georgia Supreme Court Commission on Dispute Resolution. With that, I'd like to turn to Rhett.
I'm Rhett Peden. I'm a shareholder at Davis, Matthews & Quigley. I do business law and estate planning. My father, grandfather, great-grandfather were business people, so I'm fourth generation. Seen what works, what doesn't work, and I like to help my clients grow their businesses and then one day successfully exit their businesses, whether that means they're going to sell it to someone on the inside or the outside or transition it to the next generation. That's what I try to help people do.
Thanks, Rhett. Haley is with us also. Haley, could you go ahead and give us a brief introduction of yourself?
Sure. Good morning. Haley Strong Hall, and I do a lot of the same work that Rhett does. I work with Rhett a good bit. I work in our estate planning and corporate tax sections. So we handle drafting wills, trusts, probate issues, also fiduciary litigation issues.
Thanks, Haley. Form a corporation or an LLC to protect yourself from individual liability, and I want to talk about how you do that, how you can mess that up, and what impact that could have on your business. So with the introduction of the segments out of the way, I'd like to go ahead and throw it at Rhett. A moment ago, you were introduced, and you're going to talk to us a little bit about entity selection. Can you give us?
Thank you, Matt. And I'll try to avoid the legal lingo coming from a business background. I know there's very little patience that a lot of people have when lawyers start throwing around terms. But to set the stage, when you're first starting about thinking that you want to have a business, one of the first hurdles you're going to have to cross is to figure out what type of company you want to be. And starting from the simplest is you do nothing, or you kind of do the DIY route, and you have what lawyers refer to as a sole proprietorship. Now, it's certainly the easiest way to start out, and you don't see a lawyer, you don't file any papers with the Secretary of State. You just start doing whatever you do, making widgets, and start taking in money and putting in your bank account. The downside of that is that you don't get any limited liability. You don't get protected from your creditors. And one of the main reasons a person is going to incorporate or start an entity is to protect their personal assets from business debts or people that might want to sue the business for what the business is doing. So for that reason, we never recommend that anyone has a sole proprietorship. You're also kind of limiting yourself as far as growing in the future when you're dealing with bankers trying to get money to be lent, or you're looking to get space, or you're looking to bring in partners or employees. People expect to see an entity. They expect to see some sort of company. So you have a hard time coordinating with other people if you're just in a sole proprietorship. So although a lot of people still may do that, there's a lot of downside to doing business in that form. The next step up from a sole proprietorship would be a partnership. You could have, what people generally used to have a long time ago, general partnerships. Two people get together that were otherwise sole proprietors, and they say, "Hey, we've got a great idea. Let's go work together." Again, the downside to that is that you have no protection of your personal assets, and beyond that, you've got somebody else out there who's going around as your representative, as your partner, and God knows what they're going to do. And so at the end of the day, again, if you want to have the protection of limited liability, general partnership is not where we want to see people at. Nowadays, you can have a limited partnership. Of course, you've got to file papers for that and form that type of group. A lot of times what we'll see is there'll be a limited partnership where maybe somebody gets you to invest some money into their idea, and then the person that's actually doing the work, implementing it, is the general partner, or you may have a developer, a company that's going to be the general partner, and they get a lot of people to invest money in their project. Those are the limited partners. So you have a situation, you've got more than one person. You're going to need a partnership agreement to spell out all the rights and duties that people have. But as a limited partner, you're going to get some protection. On the downside, you don't have a lot of control over what happens in the partnership. At the next level, what you're going to find are corporations. And whenever you see something called a company or Inc., you've probably got a corporation. There are two flavors that these come in. And you may have heard of C corporations and S corporations. Difference there primarily relates to tax. In your C corporations, Matt, you're going to have expenses are going to be run through the company. If anyone's working there, even as an owner, they may draw a salary. At the end of the day, though, you're going to have dividends come out to the owners. You may have heard of dividend checks coming out from, people talk about investing in companies for their dividends. When those dividends come out, they're going to be taxed a second time. First, at the company level as profit, and whatever's left over as dividends is going to come out and be taxed to the individuals, the owners who are receiving the dividends. So for that reason, that's why people a lot of times say, well, C corporations have double taxation. And, there were a lot more C corporations formed than there are today. There were a lot less options. Anytime you see a big publicly traded company, you're probably dealing with a C corporation. A lot of people think, well, so these big public companies are successful. My little small company, we need to be a C corporation just like that. Usually not the best idea, but a lot of people have that line of thinking. We try to generally get them away from that if we can. But a C corporation is historically what you would have seen. Nowadays, you see a lot more S corporations being created than C corporations. And the benefit to that is what we call pass-through taxation. If you've got an S corporation, the owners only pay tax once. You don't pay taxes on the dividends when they come out to the owners of the company. So for that reason, S corporations are generally preferable to C corporations. But there are some limitations that you run into with S corporations, so they don't work for everyone. You're limited in the number of owners that you can have. They've gone up to about 100, but if you get really big, bring in a lot of investors, give a lot of equity awards to employees to incentivize them to stay with the company, at some point you're going to run out of the number of shareholders that you can have in an S corporation. So you've got some very large, successful S corporations, but generally at some point you're going to run into a place where you're not going to be able to grow the company with equity unless you become a C corporation, because just by virtue of the number of owners you're allowed to have. And the types of owners is another issue. If you die and you're an owner of an S corporation and you have any type of trust set up under your will, for your spouse or your children, unless that trust is a very special type of trust and set up that way to be a trust that can own an S corporation, it's not a permitted owner. And having that type of owner will do something called bust the S election. And when you bust your S election, it creates a lot of adverse tax consequences, a lot of back taxes that could be due. If you have people that are international investors, people from overseas coming to invest in your company or raise money there, or people that have come here to live in the United States and they may not yet be permanent residents, those cannot be owners of an S corporation. So, again, you're limited in the type of growth or the type of investors that you can get in an S corporation. You also can only have one class of stock in an S corporation. So what does that mean? It means if you want to bring in an investor and give them a little extra kick on their equity, you can't do that. Or if you want to bring in an employee, but put certain restrictions on the type of ownership they can have in the company. Again, you're running into issues with how flexible the S corporation can be. You can't always do with the S corporation what you might want to do.
Right along those lines, if you make an S election, if you form a corporation as an S corporation, are you stuck with that for life? Can you go to a C corp, or if you're a C corp, can you go to an S corp later on?
You can go in and out of that status, but you're limited in how often you can do that. There's generally a 5-year period once you change that election before you can go back to being the other. So it's not as simple as flipping a switch. There are rules that limit how often you can do that. And again, when you switch from one tax system to the other, there can always be consequences that you have to be aware of. So it's not as easy as flipping a switch, but you do have some flexibility. So where does that leave you? If you don't have a sole proprietorship, or we don't recommend that, you're not a partnership, you're not a C corporation or an S corporation, the other option that's out there is the limited liability company. Whenever you see LLC, that's what that is, a limited liability company. They haven't been around all that long, just really since the 90s is when they took off, but they're very flexible. In fact, when most people come into our office, that's probably the first thing we're thinking is LLC, just because of the flexibility. You can have different types of owners, which is not always an option with an S corporation. You still get the benefit of having pass-through taxation or only one level of tax, so that's also a benefit. You can have different types of ownership classes. You can have people that have preferred interest. You can treat investors differently than people that work at the company, and you don't have to decide all that up front. You can change things along the way in an LLC, unlike how you could change things necessarily in a corporation or in a partnership. You've just got that flexibility to go in and out of different sorts of status. If you're a single member LLC, which a lot of startups are, you have the benefit of being something called a disregarded entity. What that means is when Uncle Sam looks at you, there's no difference between you and the company from a tax standpoint. Everything just flows through onto your Schedule C on your individual tax return. You don't have to file a separate income tax return for the LLC, but still you get the benefit of protecting your assets of limited liability, even though from a tax standpoint there's no difference between you and the company. Some advisors believe that maybe it's good to elect out of that, or maybe have in another owner with you, even with a minority owner, just so that you would be a partnership instead of a disregarded entity. And being taxed as a partnership would mean that you would have a partnership tax return, and then you would get what's called a K-1, which you would attach to your individual tax return. And it may look a little bit cleaner. It may be a little bit easier to keep your business assets separate from your individual assets. And Matt can probably talk a little bit later about how that might help from a standpoint of really buttoning down that limited liability protection and what's called piercing the corporate veil. So all of those are benefits that you can get from an LLC. A lot of startup companies, especially in the tech space, for a long time felt that they thought that they would go public at the end of the day, and so they should start off as a C corporation. The LLC didn't have the cachet that being a corporation had, but what I've seen over time is that's really changed. Is that people are much more familiar with LLCs today. They're much more comfortable with them. They realize the flexibility. At the end of the day, if you need to change your structure, you can do that. So a lot more people now are starting up as LLCs. You can actually elect under the check the box regulations, which makes it easy for you to decide what type of entity you're going to be from the perspective of the IRS. You can actually elect to be taxed as an S corporation if you're an LLC. Now, why would anyone want to do that? The one issue you get into if you're an owner operator, which a lot of our clients are, you're just starting out. You don't have the funds to hire a bunch of people. You're doing it yourself. You're actively involved in the business. So if you're actively involved in the business, you have an LLC. The employment taxes that apply to your income are going to be attached to all of the income flowing through to you, including the Medicare portion, which even goes beyond the Social Security base, is going to be taxed if you're the owner of an LLC and you're not an S corporation. What happens with an S corporation is you take a salary as an operator, whatever a fair salary would be. You pay your employment taxes on that base, and then if there's any money left over at the end of the year, you get a dividend. You're not taxed again on that income. You've already paid the taxes, but that dividend distribution is not going to be subject to the Medicare portion of the employment taxes. So you have a little bit better tax situation if you're an owner-operator and you have an S-Corp instead of an LLC. But, of course, you have to be paying yourself a reasonable salary. The IRS, doesn't want people to abuse that, so they will, an audit, that's an issue that's going to be looked at to make sure that you're respecting the corporation, paying the right type of salary. So that might be a reason, though, that someone might want to choose to be an S corporation instead of an LLC. A lot of times what we'll actually see or get clients into is you may have a operating business where you actually make your widgets, do what it is that you do. You do that through an S corporation. And then if you have any real estate, you'll hold that in a separate LLC. And the benefit of that is twofold. One, you have the assets of both businesses are separate. They're both protected. If there's something that goes wrong with one business, it doesn't affect the assets of the other part of your business. And also, an S corporation is not really a good vehicle to hold real estate. It could throw off a lot of passive income, which is you're not allowed to hold that type of income inside of an S corp. It could endanger the S election. That's kind of a brief overview of the different types of entities that our clients would be getting into, and some of the pros and cons of each of those.
Okay, thanks, Rhett. What do you have for us?
Sure. So this list, first of all, I want to say it's not complete. It's going to depend on which entity you decide to go with, which type of business that you're operating. So for each of these, I would recommend consulting with an advisor just to make sure you're covering your bases and getting everything filed and obtained that you need to work on. So to start, first of all, once you've selected what kind of entity you want, you'll need to have documents that govern how your business operates. So that's going to depend on which type of entity you choose. So for instance, if you have an LLC, you'll want to have an operating agreement. You may want a partnership agreement or a shareholders agreement. So that depends on the entity that you've chosen. Once you have those in place, you'll want to register. So you'll register with the Secretary of State of the state where you're doing business. So that will involve pretty simple filings with the Secretary of State, articles of organization if you're an LLC, for instance, articles of incorporation if you're a corporation. You'll have an initial annual registration, and then that will be renewed. That will need to be renewed every year. And then also, if you're doing business in another state, you want to consider whether you have to register in that state as well. So once you've registered, you'll need to obtain a taxpayer identification, or it's also called an employer identification number. They mean the same thing. They're often used interchangeably. So you'll use this number for filing all of your tax returns, your state, federal income tax filings, payroll taxes, any informational returns that you may need to file, for instance, W-2s, 1099 forms that you may need to send out. You'll also use that number to establish your bank account for your company. Aside from that, you'll have a number of state requirements. Most of these are through the Department of Revenue with your state. If your business is going to be subject to sales tax, you'll want to register for sales and use tax payments and withholdings. If you're going to have employees, you'll apply for a payroll withholding number. On the federal side, you also need a number with the Department of Labor for unemployment taxes. You will also have a number of federal and state forms that should be filled out each time you hire an employee. And then depending on the state you're in, you may be required to have workers' comp insurance for your employees. In addition, you'll also have business licenses and other tax numbers that are going to depend on what type of business you're operating. For example, you may need an alcohol license, tobacco license, things like that. So also on the local level, you may need other business licenses specific to the city or county that you're in. And so once you have all of that in place, you're going to have ongoing requirements, annual registrations, any required meetings that you're supposed to have. You'll want to make sure to keep accurate records of your business and all major decisions, major transactions. And just generally, you want to just treat the entity as a separate legal entity to avoid any other problems that may arise.
Thanks, Haley. That kind of transitions really well into our last topic, but also what happens if you do that. So, things that happen a lot that put the corporate veil at risk. And if the corporate veil is broken, then you could be subject to those individual liabilities of the business. The first and probably the biggest is commingling. And really what that means is that you and the company are really treating the money that comes through the company as your own money. You're not keeping things separate. Silly examples like paying your mortgage out of the bank account of the business. That's a bad idea. Paying for other personal expenses out of the business that aren't related in any way to the business. Those are typically commingling aspects. Using your own personal bank account instead of having a separate bank account for your business. If you're a corporation, you don't want to be doing that if you want to try to protect yourself from those liabilities. Also, you also have the issue of insolvency and undercapitalization. So if your business is entering into a contract where you're committing to pay a certain amount of money per month for something and you have no money in your bank account and you have no realistic expectation that you're going to have the money on time to pay it as it becomes due, you've got an issue with insolvency and undercapitalization. Those are factors that play into what's called piercing the corporate veil or disregarding the corporate veil. And Haley talked a lot about governing documents, your bylaws, operating agreement, shareholders agreement. Having those documents helps protect the corporate veil. If you don't have those documents, it's essentially you are attempting to disregard the corporate veil. You want the protection, but you're not going through the steps, the process to protect yourself. And Haley mentioned keeping good documentation of meetings and big decisions that come through the business as well. And you want to have meeting minutes. You want to make sure that you're covering your bases with respect to corporate decision making.
Matt, these sound all kind of like scenarios I'm sure you've personally encountered. I know when someone's being sued for whatever reason, one of the first things someone like you as a litigator is going to come in and do is depose that person. And I think one of the first questions that you're going to be asking them is, can you show me all of these documents?
Absolutely. That would be one of the first discovery items that I would ask for with respect to suing a corporation. You would definitely be asking for organizational documents. And depending on what you have as far as existing knowledge, you may be asking for more with respect to financial information and organizational information at that time as well. Another issue, in addition to the documentation, is signing in your personal capacity. A lot of folks, they have a company, and then they sign a contract, and they don't put in on the contract, as president of XYZ. Instead, they just sign Matt Thiry. Well, that's a problem. You need to be signing in your corporate capacity. So you in effect, are bypassing the corporate veil, and a lot of times litigators don't have to do much at that point to get through the corporate veil. What happens if you mess up? You can then be held liable for the corporate debt. So the entire purpose of forming your corporation for the protection kind of goes out the window, and now you're almost in the same boat as if you were a sole proprietor. So there's a lot of things. Most of them are common sense on how to protect yourself from having these liabilities pass through to you. But if to the unwary, to the person who lacks due care, they could easily step into a situation where they are finding themselves liable for corporate debts. Mm-hmm. So that's kind of a common thing. Silly example. I had a litigation case with I was going through a general ledger, and there were I asked the question in a deposition, do you have any animals for business purposes? And a very silly question. A lot of people in the room kind of chuckled. It was I was deposing a general contractor, and I knew very well that he did not have any animals for business purposes. But a few minutes later in the deposition, the laughter stopped because we asked then, okay, you said you have no animals for business purposes, but then why is it that we have 35 charges on your corporate account to PetSmart? What we were drawing out is the fact that that person was using the corporate account for personal expenses. And that was one of a few, and I say few kind of sarcastically, examples within that particular case where the owner had disregarded the corporate entity on their own. But it's an example, and it's a silly example, and it's one that's easy to stick in the minds of folks when you talk about, animals for business purposes. Of course, it's a silly example. You want to keep your business assets, and your personal assets, and mixing the two can get you into a lot of hot water.
Right. It's one of the constant battles that you, unfortunately, with closely held companies, which is a lot of the type of clients that we deal with, is to preach to them, hey, you can't just walk out of this room and forget everything that we just did. All of this is going to be for naught. You've just paid a lawyer to basically do nothing but twiddle his thumbs if you're going to go out there and start using the company as your personal piggy bank. And a lot of people will, unless you're really held to account, they have a tendency to go out there and do that, and they think, well, this is my company, or it can be an issue even sometimes when you get into a partnership situation where you have more than one person at the company, and they still look at that as kind of their personal piggy bank, and that creates another set of problems because there are duties that you owe to your partners and to the other owners of the company, and if you start neglecting those, you can quickly find yourself in hot water and
litigation.
So not only have you then pierced the corporate veil with respect to company debts to outsiders, to third parties, you've got a whole another raft causes of action between the owners.
Exactly. And that's never good for the business.
No, it's not. But hopefully what we set someone up with is flexible enough that they can operate, grow the business, and I know we'll get into this in later episodes down the road, but a lot of what we're going to be doing on the front end, starting up the company, is going to affect how you're going to be able to, at the end of the day, cash in on all that hard work when you get ready to sell the company.
Exactly. Well, and with that, I'd like to thank everyone for joining us today. Hope everyone found this to be helpful. You can find us online at www.dmqlaw.com. You can reach us at 404-261-3900. You can follow us on Twitter at dmqlaw.com. You can follow me on Twitter at Matthew Thiry. Thank you for joining us, and we hope you'll join us again for the next episode of Planning Successfully.